Thank you. So, as she said, my name is Bethany Nicholson, and I'm an associate lawyer at Gluckstein Lawyers, where my practice focuses on medical malpractice litigation. Today, I'm going to be speaking about effective advocacy in medical malpractice cases. Now, I want to start by saying that there isn't a single formula for being an effective advocate. Each case, client, and lawyer is different, but what I hope to share today are some of the principles and practices that guide how we at Gluckstein Lawyers try to advocate effectively, from the outset of a case through to resolution, and sometimes even beyond. And I will apologize at the very outset that some of the topics have already been covered in some of the earlier presentations, but I think it goes towards how important these points are in being an effective advocate. So what is effective advocacy? Effective advocacy in medical malpractice is a skilled and principled representation of a client's case through a combination of legal expertise, medical understanding, and effective communication. This is particularly vital in medical malpractice cases, which involve complex medical concepts and where our clients are relying on us to navigate both the law and the medicine. And effective advocacy is essential to persuasively and strategically advance our clients' cases. But it is more than just persuasive argument. It encompasses strategy, preparation, and the ability to master the medicine to fully understand the complexities of the case at hand. Effective advocacy begins long before a trial. It begins at the initial intake and continues through the entire litigation. So how do we effectively advocate? There are many elements that contribute to effective advocacy, including trauma-informed lawyering and effective and persuasive communication. However, as this is only a 15-minute presentation and we are at the end of the day, I'm going to focus on 3 elements that I believe are often overlooked, which are essential to effective advocacy in medical malpractice cases, and that's preparation, understanding the medicine, and early case theory development. And all 3 of these interact with each other, so it's important to understand the basics and how they interplay with each other. And also, even if you already know these things, it's important to remind ourselves why these are important pieces for effective advocacy. So preparation is the backbone of effective advocacy. It's where credibility is built, and it ensures that cases can be won long before anyone steps into a courtroom. Knowing your case inside and out helps you at every stage of the litigation. Effective preparation starts at intake. It requires a robust intake memo and calls, preparing detailed memos immediately following these cases so that you are aware of all the complexities in the case from the very outset. Preparation also includes establishing client expectations early on in the case. And this is a step I see is often overlooked. I've spoken to many potential clients who already have a case started and are looking for new counsel for a variety of reasons. Maybe their counsel are retiring, or it was started because they were close to the limitations. And during these calls, like I do with any potential new client, I go over some of the basics of medical malpractice claims and litigation in general. And it amazes me how often I'm told I'm the first person to explain any of this to them. So I think it's really fundamental that we're establishing clients' expectations from the first initial intake. So establishing client expectations involves clear and continuous communication about not just the strengths of a case, but also the weaknesses. And this should start at the very beginning so that there's no question about where a case might go, and they know all the possible arguments that might be brought up during their case. And by doing this, they are aware of the challenges and risks along the way and are not caught just then by surprise when you get to mediation and they're hearing for the first time some of the weaknesses in their case. In addition to the strengths and weaknesses, you should also establish what is expected from them early in the lawsuit. and as well the lawsuit process generally. So as Jan had pointed out previously, all the steps in the litigation are very important to explain. So this ensures a better prosecution of the case. An example of this is advising clients to track all of their out-of-pocket expenses from the very beginning, especially if this is going to be a complex case. It's going to run over many years that involve a lot of different purchases and services that are being paid along the way. If they're tracking those expenses from the very beginning, it will make sure that the process is run so much smoother and that you're not just scrambling a month before a mediation asking them to provide you with all of their out-of-pocket expenses. They've been told from the very beginning it's their expectation to track all their out-of-pocket expenses so that everything can be organized. This way you can also provide a detailed, organized out-of-pocket schedule with accompanying receipts, and it shows defense that you're well prepared. So preparation also includes early expert consultation, and that's going to be discussed later in the presentation. But most importantly, preparation involves detailed review and analysis of the medical records from the outset of the case. So to effectively advocate in a medical malpractice case, you have to know your case better than anyone else, including your experts. That means constructing a detailed chronology that ties together the clinical events, any communications, and decisions made by your potential defendants. Instead of having various entries strewed across multiple records, a detailed chronology provides you with the full picture. It allows you to better understand where the standards of care may have deviated, where opportunities for interventions were missed, and how those moments connect to the outcome. Identification of red flags are much easier to do when you have the full clinical context. Otherwise, they may span multiple pages in a record and be very difficult to comprehend. Preparing detailed chronologies also allow for easy navigation through the records at any stage of the litigation, and it makes drafting retaining letters to experts and discussing your cases with your experts much easier. For our medical malpractice cases, we use Excel to create our chronologies. We began using them in our birth injury cases, but have adapted them to all of our medical malpractice cases. Our Excel chronologies are tailored to each specific file. So for example, a birth injury case will have 3 separate sheets, one for antenatal history, one for intrapartum, and one for neonatal. Each sheet will have standard headings, which we also will adapt to the specific case needs. So here is an example of one of our, or I guess just a snippet of one of our Excel spreadsheets. This one is from the intrapartum sheet, and as you can see, we list the date, time, the reference, so what page number from which record, as well as the fetal heart rate information, the uterine activity, labor progress, maternal vitals, keywords, the parties, and then the actual contents of any notes from nurses, doctors, midwives, etc. So this is essential to understanding the order of events, particularly in birth injury cases where every minute matters. Having the records summarized this way helps when we're comparing nurses or doctors' interpretations of a fetal heart rate pattern, for example, against the actual tracing to see where maybe they didn't record accurate information. And it can also easily show how a labor progressed over multiple hours, because if we're looking in these kinds of records, especially in the birth injury cases, there's certain information contained in a record called a partogram, and then you'll get the nursing notes in a different area, and then the doctor's notes are in a different area, and then you have the operative note. And when we do these chronologies, we put them in order of when the events actually occurred, so we can compare what one party is saying about a certain event versus another. And it's very, very, very beneficial for understanding the whole of our case. We also use it to effectively prepare for our examinations for discovery and discuss the case with our experts. So if our expert is asking us information about a case, so they ask, what was this lab entry, or when was the last time a vaginal examination was done, we're able to easily find that information and provide the page number where they can later find that information. So it's very, very beneficial. I cannot stress enough how useful these chronologies are and how they help us to effectively advocate for our clients. And I will say they do take a lot of time to prepare at the very beginning of our cases, but they do save us so much time in the long run. So true preparation means being the most informed person in the room, including on the medicine. As we saw with Richard's presentation earlier, he definitely embodies this idea. He knows the medicine better than most of our experts, if not all of our experts. And so he is a true testament of how important it is to understand the medicine, and he's always teaching us about the medicine as well. So it doesn't matter how well prepared you are in terms of having a detailed summary. If you don't understand the medical concepts at issue and how the clinical picture fits into them, you cannot meaningfully engage with your experts or examine the defendants, who are subject matter experts themselves, if you don't understand the medicine. So it starts with a clear grasp of the normal clinical course and standards of care. Before we can identify what went wrong, we need to understand how, for example, labor typically progresses, or what a normal fetal heart rate pattern looks like, and what interventions are expected. This foundation allows us to recognize subtle deviations that might seem insignificant at first glance, but are often where the case turns. When you can discuss standards of care and causation confidently and accurately, you also gain credibility, not only with your experts, but also with opposing counsel, mediators, and the court. A deep understanding of the medicine also allows you to anticipate defense arguments and deal with them head on. In almost every case, the defense will argue that the event was unpredictable, unavoidable, unrelated to the alleged breach, or that any alleged delay made no difference in the outcome. When you know the medicine, you can challenge those narratives with precision using the literature and the clinical circumstances of your case to demonstrate why timing, intervention, or monitoring mattered. This medical fluency strengthens your case theory development and leads to sharper, more focused examinations for discovery, because you know which questions expose inconsistencies and which issues truly matter to the standard of care and causation. This, of course, will be extremely important in the new era of the rules of civil procedure, which will most likely limit the length of our examinations for discovery. I've heard anywhere from 2 to 4 hours. So imagine trying to do an examination for discovery in 2 hours. It will be incredibly important to know exactly what questions really matter in your case, and there's no way to know what those are unless you understand the medicine. So having a good understanding of the medicine also allows for better engagement with your experts, because our experts are not flawless. They may not always have considered every angle or theory, or may have made some mistakes. So when you have a good grasp on the medicine, you're able to challenge them on their opinions, to fully flesh out the case theory and potential weaknesses. We also must understand the medical knowledge is not static. Keeping up to date with the literature ensures your arguments are evidence-based and contemporary, and I think Richard covered that point pretty well in his autism presentation about how, he had a case where it wasn't supported by the literature that was out there, but when he waited 10 years, the literature caught up to where it should have been in the first place and was able to resolve that case. So it's important to stay up to date with the medicine as well. So as advocates, we also serve as translators. We must turn complex medical concepts into clear, accessible language. And this is important for not just our understanding, but also for judges, juries, and also our clients who are not medical experts and probably do not understand the medical complexities at play. Finally, Never rely solely on your expert reports. They're tools, but they're not a substitute for your own understanding. You need to internalize the medicine so deeply that you can explain it confidently in plain language. So once we've reviewed all the records, prepared our chronology, and have done enough research to understand the medicine, we can begin to develop our theory of the case. And this should be done very early in your case. So early case theory development is the compass that guides every strategic decision in a medical malpractice case. From the very beginning, we work to identify the core narrative, the central theory that connects the client's story, the medical evidence, and the legal framework. For example, in our birth injury cases, a common theme might be that a preventable delay in response to an abnormal fetal heart rate pattern during labor led to a hypoxic ischemic brain injury. Defining this theory and the timing and the mechanism of injury early allows us to focus our investigation, coordinate our experts, which will include, in birth injury cases, often obstetrical, neonatology, neuroradiology, neurology, and pediatrics. And it also allows us to focus and conduct focused examinations for discovery in a way that consistently supports our theory of the case. Without a clear theory, even the most detailed records review and expert reports can become a collection of disconnected facts rather than a compelling story. It also runs the risk that your expert reports will contradict each other in subtle ways, which will open the door to a defense. Developing your case theory early also allows you to stress test your assumptions against potential defense arguments. You can anticipate counter-narratives, consider alternative theories, and ensure your evidence directly addresses the weaknesses before they're exploited. This proactive approach ensures that your examinations for discovery and expert consultations are all strategically aligned. It also reduces surprises at mediation or trial because your theory has already been challenged, refined, and validated against both the medical and legal realities of the case. Finally, a strong early case theory provides a framework for communication and persuasion, and it informs how you present the complex medical evidence in an accessible language, how you structure timelines, and how you explain causation to judges, juries, and mediators. It also helps to maintain focus over the long course of litigation. So effective advocacy doesn't end when a single case is resolved. One critical aspect of advocacy is staying current with the developments in medicine, law, and procedure. This involves reviewing new studies that come out, or staying current on the changes in our legal system. As medical malpractice lawyers, part of our role is also to help shape the system in which our clients' cases unfold. For example, the upcoming changes to the rules of civil procedure will impact how we investigate and present our cases, and our team has been heavily involved in various responses to the Phase 2 consultation report and ongoing developments. By staying informed and actively trying to shape these changes, we ensure our advocacy is not only effective for the immediate case, but also strategically aligned with the evolving legal and clinical landscape for all medical malpractice cases. And you really don't have to be a senior counsel to get involved in shaping the system. You know, I've only been practicing for 3 years, and I was involved in the CCLA responses. And it's important to know, too, that a lot of the time these responses are by various areas of the bar and are not always going to have a medical malpractice perspective. I was asked to be on their response committee because they didn't have anybody with that background. And so I thought it was a very important piece of being an effective advocate was really bringing my clients and our clients' perspectives to the table so that all types of cases were being considered when they were doing their response to the Phase 2 consultation report. I've also had the exceptional privilege of seeing firsthand how we as lawyers can help shape the medical and justice system for the better through intervention work. This is where our advocacy can clarify or strengthen the law in ways that benefit not just one client, but all future families facing medical malpractice claims. Engaging in this kind of work allows us to highlight systemic issues, test legal principles, and set precedents that improve outcomes for others while advancing accountability in healthcare. For example, Richard and Jan, on behalf of the Ontario Trial Lawyers Association, and Pinta on behalf of the Ontario Coalition for Abortion Clinics, will be interveners at the Supreme Court of Canada on the Hemmings and Pang case, touching on issues involving causation and access to abortion care. As a more junior lawyer, it's very inspiring to see the work that my colleagues are doing to further our clients' rights outside of just their immediate cases. So finally, advocacy beyond the case involves a broader commitment to the profession and the community. This can include educating colleagues, like with Risky Business, participating in reforms, or collaborating on research and policy initiatives. By engaging in these activities, we strengthen the system as a whole, which enables us to effectively advocate for our clients. Thank you.